All right. Court of Appeal, State of Florida, now saying, the Honorable Carrie Ann Watson, presiding. All persons having visited before the court, strong energy of attention and will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Good morning and welcome to a session of the 6th District Court of Appeal. I'm Carrie Ann Wozniak from Orange County, and to my left and your right is Judge Roger Ganem, and to my right and your left is Judge Joshua Mize. We have two cases today, and just a reminder that this is being live streamed on YouTube and recorded. We'll go ahead and get started with the first case. It's 24-0855. Allstate Property and Casualty Insurance Company versus Carlos Diaz. Good morning. Can you tell me how much time you would like for rebuttal?
6 minutes, Your Honor.
6 minutes. Okay, and you may proceed.
May it please the court, Kevin Franz on behalf of Allstate. Allstate was denied the right to a fair trial based on plaintiff using cancer as both a sword to evoke sympathy from the jury and a shield to prevent Allstate from discovering relevant evidence. As to the shield, the plaintiff injected his cancer into this case at deposition, testifying that the reason that he didn't treat for his neck and back for 2 to 3 years was due to treating for cancer. The plaintiff then successfully prevented the defendant from obtaining records related to cancer, arguing they're clearly irrelevant and had no bearing on the motor vehicle accident. But these were relevant for several reasons. First of all,
did they prevent your client from getting the records? As I understood, the request was block the records request or do an in-camera review. And I didn't see anywhere in the record where Allstate followed up and said, we want the in-camera review, do that.
we had a hearing on the motion for protective order, motion to compel. Plaintiff's counsel said, I have 2006 records, which all relate to cancer. This has to be done via in-camera review. The defense argued we don't know what's in them. We're entitled to have the court look at them and determine what is in them if they're relevant. The judge said, I'm going to take this under consideration, reserve ruling, and then it entered a clear order denying the motion, compelling the records, saying that these are irrelevant and they are protected by the privacy rights of the Constitution.
So the records that were withheld, was there any follow-up request for we want an in-camera review on the ones that were withheld?
There was not a request after there was a definitive ruling written by court order saying these records are not going to the defendant, period. So there was no need for a follow-up because this was preserved based on that written order. These were relevant to, of course, verify and impeach whether what the plaintiff said in deposition was true or not. That's why in every personal injury action, you obtain records to determine whether or not what they say is accurate. The plaintiff says is accurate. Additionally, to see if there was any physical exams during these 3 years of treatment for cancer that may have discussed, oh, I'm having a tremendous amount of neck and back pain, or I'm having zero neck and back pain. The trial court abused its discretion in precluding this because cancer was placed at issue. And this court in Value versus Nevado, just from this year, an issue, the court agreed that the plaintiff waived the constitutional right to privacy and medical records relevant to the claims. What's interesting in that case is the claims in that case were for the neck and back, same as here. What's interesting about that case is that the records at issue were dental records, something you would not think would be particularly relevant to the neck or back. But in the court's opinion, it said that people will have discussions with doctors about all of their aches and pains, giving the example that dentists can also indicate when you're having neck pain. This is exactly what we needed to see to verify plaintiff's complaints. And I do want to mention that there was a petition for writ to obtain these records to the 5th DCA. That court simply dismissed the case for lack of jurisdiction, finding that we did not establish irreparable harm. All that means is that the issue can be addressed on plenary appeal, which is what we're doing.
Well, and the 5th said that you could get the records from other sources, correct? Did you do that?
It said that it denied the petition because we didn't establish that we could not get the records from additional. It didn't say you can go ahead and get records from additional. But the bottom line is, I actually disagree with that because the only way you can know what's in these records is to actually get these records. There's no other source that we could go to learn that. And the plaintiff then used this as a sword at trial. Now, what's ironic is that the plaintiff was the one who moved to exclude all evidence of cancer in their first motion in limine at paragraph 35, and the 10th motion in limine sought to exclude evidence and records regarding prostate and thyroid cancer treatment or illnesses.
So at trial, we don't have the opening statement in the record. Is that correct?
Correct.
Okay, so I noticed in closing argument, Allstate did argue, well, if he was really in that much pain during those 2 years, then he would have sought treatment. So I don't know if, you know, Diaz made that an issue, Mr. Diaz made that an issue in the opening statement because we don't have that, came up during the trial, but it seems like Allstate did bring it up, at least in the closing argument I saw.
Well, the plaintiff obviously closed first, and I will get to that and quote from the closing. So the plaintiff raised that. If the court reads the transcript in its entirety, I'm not even sure that the defense mentioned word cancer more than 1 or 2 times the entire time. The plaintiff, however, used this about 48 times. Now, the 2001 thyroid cancer has absolutely no relevance in this case, if that was discussed at trial. And the 2000 prostate cancer has limited relevance, maybe to one time explain the gaps in treatment.
But I think Judge Wozniak's point is if you argue, hey, there's this 2-year period that they didn't seek treatment, the natural response to that is we had a reason to not seek treatment. We were dealing with some other more serious issue, right? And so, you know, once you, assuming you open that door, and like I said, we don't have the opening, we just have the closing, and I know that creates a distinction. But once you open that, it's not like you say, well, we open the door, they only get to say it twice and not 48 times, right? Like if you open it, you open it.
And the problem is that we were denied discovery on this relevant issue then. If cancer is a relevant issue and before trial started, the trial court judge, who was different from the initial judge, denied our defense counsel did not remember that cancer had been excluded from trial based on written orders. And when he raised it, he remembered that it was her, but he didn't remember the ruling. And he argued that this was prejudicial and irrelevant. And the new trial court judge simply said, this is not timely, I'm denying it. So that, we did not open the door to this coming in. The trial court judge allowed this to come in.
Well, I mean, you asked the trial court to address the issue. Now, granted, it seems that was clearly under, you know, your trial counsel misremembered that there was already an order in place. But nonetheless, your trial counsel did raise it, asked the court for a ruling, even though there was already a limiting order in place. So you tell the trial court there's no order in place. And so it looks to the trial court like your motion is a new motion that you just didn't get a timely ruling on. Trial court denies it as untimely. Is there no part of that that's on your trial counsel?
There is some, but I would suggest there is some on opposing counsel.
Because in your briefs, you basically, you said it a few times, like they, you know, Diaz's trial counsel should have stood up and corrected him. Well, I'm not sure what rule would have required them to do that. B, that kind of assumes they remembered when you didn't remember, right? Like you're not you, but your trial counsel, right? I mean, we can't get in their head and know what they were thinking when your trial counsel raised this issue. So in my mind, you ask the trial court to adjudicate an issue, you're kind of opening the door to that being adjudicated or re-adjudicated at that time. No one else did that. It's not like they said, Judge, we want to revisit this. Your trial counsel did that.
I do think candor to the court, and I can't get into my.
But if your trial counsel didn't remember, how can we assume they remembered? Like, how do we know what was going through their head at that moment in order to say they had a duty of candor to the court? And how do we know they've interpreted your request as knowing there wasn't a, you know, why would they assume you didn't know there was an order not in place as opposed to you're asking the court to revisit it?
And I concede that, Your Honor. I think the main point is this is an auto accident case about neck and back injuries, and cancer became the absolute focus of this case. So I think this court can look and see, was this verdict based on sympathy, based on the focus being of cancer? Now, if Your Honor is correct and says, look, you can explain the gap in treatment one time, or you don't even have to use cancer. You can say due to an illness or whatnot. But if we can't get the records, if cancer is relevant to this case, we are entitled to the records to determine whether or not they substantiate the plaintiff's claim.
Well, I mean, imagine this for an offense. You don't get the records, okay? But then at trial, you're the one, at least we know what happened in the closing, that says, hey, there's this 2-year gap. So now an issue which you didn't get records on, but which might not have come in, right? You also had an order prohibiting anybody from talking about it. You then ask the judge to re-examine the issue at trial, way past the discovery issue, re-examine the issue of whether this is going to be admissible or able to be talked about, and B, give them a reason to talk about it. Because you say, Jay, there's this 2-year period where they didn't get any treatment.
I think the problem, though, is I could not be here making this argument if there was one line of testimony where the plaintiff said, I couldn't get the treatment because I was there for cancer, because I was treated for cancer. But here's the plethora of evidence that caused a runaway jury verdict in a simple auto accident case to award more than the plaintiff asked for. Carlos Diaz. This goes to way more than just explaining a gap in treatment, testifying that he agreed he was full of life until he was diagnosed with thyroid cancer. Surviving cancer changes the way that you look at life. You see things differently. Having survived cancer earlier, he was asked 20 years earlier, how did you approach prostate cancer the second time you had to deal with it? The second time was hard, but this is my prostate. This has nothing to do with gaps in treatment, by the way. This is just done to evoke sympathy from the jury. Even counsel had to tell him this was obviously extremely emotional. Counsel even had to just say, quote, just take a deep breath. And then we get into COVID, where he was testified that he was immunosuppressed because of cancer. He got very scared because of that. This goes way beyond explaining very briefly that cancer caused me to not treat for my neck and back.
That goes to my point, like how if a door is opened, is it only open to some narrow extent? Like how would we draw that line that says, all right, if you open a door, they get to bring it in, but only a little bit. But like, how would we decide how much they get to discuss something that you've opened the door to? And what would be the standard we would apply to determine that?
I wouldn't agree that the door was open. I don't think that the defense did anything to open the door. In fact, it was the only reason this even became an issue because the plaintiff testified in deposition. The reason that I didn't have this was the reason I didn't treat for 2 to 3 years for my neck and back was because of my.
Do you contest Judge Wozniak's characterization of the closing that your trial counsel said there was this 2-year period?
Maybe in rebuttal, but I'd like to actually, but that's not opening the door because the plaintiff went first and said, Mr. Diaz has had some hurdles in his life that he didn't ask for. 2 bouts of cancer, survived one by more than 20 years ago, another one just 2 years ago. Those have nothing to do with this case, although it's been discussed. He has overcome those things, but life says that if life's events through no fault of your own bring you to living your life on the edge of a cliff, then this trial is about what did it take to push someone off that cliff. The focus of this trial should have been on what did it take to push him off this cliff. So that had nothing to do with this gap in treatment.
Well, but I think the phrase was though, we know you said in your closing, and granted, they said some things first. We don't know what you said in your open.
In opening statements, which.
Yeah. So what if your counsel had said the same thing in opening as they did in closing?
Based on the totality of the entire record, when defense counsel maybe said the word cancer once or twice, it's hard to believe that he would have said this has to do with that cancer affected this person so much that this accident is what pushed him off the cliff. Plaintiff's counsel combined cancer, which has very little to do with this case, to basically said that gets him to this point, just at the edge of the cliff, and this auto accident pushed him over. This case is not about cancer, but it was made about cancer. If cancer was relevant to some extent, it was an abuse of discretion in precluding us from obtaining discovery records related to cancer. And if it wasn't relevant, then it was abuse of discretion in admitting this evidence. The combination of allowing cancer to become the theme at trial while preventing the defense from viewing records deprived Allstate of a fair trial. We'd ask the court to reverse and remand.
Can we move on to the bias of Dr. Mahan issue? Just before you sit down, I do have a question on that.
Yes.
Okay, so if we were to find that there was error there in not allowing the question about Dr. Mahan being in opposing counsel's wedding, There's the harmless error issue. Special West Boca, that case says that the appellee is supposed to address, it's their burden on harmless error. My reading of the answer brief is that it was not addressed in the answer brief. What do we do at that point? Do we have to sua sponte analyze harmless error? Did appellee waive that issue? What do we do with that?
Appellee waived the issue. If we raised the issue in our initial brief, and it's, as you said, it was error, especially under the McKinney-Graham case, which literally this exact issue happened in. And if they don't explain, it's their burden under Special versus Boca. They have to prove that there is no reasonable possibility that that could have led to contribute to the verdict. It's not our burden to do so. And very briefly, this court very briefly issued the Geico versus Ibarra's decision very recently on that it is an error as a matter of law to enter a judgment over the policy limits, absent of bad faith. This court needs to follow that, as this court has already issued that opinion, and the judgment in this case has to, at minimum, has to be reversed to limit the judgment to the policy limits. Thank you.
Morning, judges. Jeffrey Bird. I was trial counsel and I'm appellate counsel. I want to begin by saying I have a duty of candor to this court as well. And with respect to his citation to the VAR's decision, he's accurate. So therefore, I have to concede that with respect to the judgment that was entered by Judge Schreiber, who at that time did not have the benefit of the VAR's decision that just came out 2 weeks ago, this court should remand with instructions to enter a judgment consistent with the VAR's decision. Now, I want to be clear. Judge Schreiber made a ruling based upon the only case that existed at that time. So I don't think it was fair to characterize Judge Schreiber, who's a very experienced judge, as having committed error when she was following the only case that existed at that time, which was the Walker decision. However, I understand that you must make a decision based upon the current state of the law, not as it was back then. So while I did concede in the brief that this panel might do that because a case called Finson came out from a different DCA, I now have to acknowledge and concede that this court, it's not a final decision, so it's not technically binding, but I don't want to split hairs like that, that the VAR's decision does appear to suggest that this judgment was entered in error, not because Judge Schreiber didn't correctly analyze the law, but because the law has just simply changed or has been refined, let's say. It is curious to me why no DCA, now 3 DCAs have called into question the 4th DCA's decision of Walker, and nobody has certified it yet to the Supreme Court, this conflict, but there's a whole discussion about dicta that I'll bypass for purposes of this oral argument. So, duty of candor, I do acknowledge that as to that limited technical issue on the entry of the judgment, that the court should remand with instructions to follow the more recent VAR's decision. However, as to all other issues, neither Judges Weiss nor Judge Schreiber abuse their discretion in any respect. With respect to Judge Mize, your question, Allstate did not at any point over a period of years ask for an in-camera inspection. This notion that the plaintiff asked for an in-camera inspection is specious because why would I ask the court? I'm the one that withheld the records. I complied with an order that was entered by stipulation that said if records were obtained that violated my client's constitutional right of privacy, that I was permitted to withhold them, give notice to Allstate, which I did, give notice to the court, which I did. We held a hearing, lengthy debate and discussion, and this notion that I somehow argued that the court should have reviewed 2,006 pages of cancer treatment records. It all related to my client's prostate. And I think all of us could understand why one would not want that type of information put out in a public domain. They didn't ask for an in-camera inspection. They didn't ask for a special master. They didn't ask for anything. In fact, they did nothing after Judge Weiss entered an order saying, well, I'm not going to let you get the records, but you can get the information by other means. And they did nothing after they appealed to then 50CA, was the binding appellate authority. They did nothing after the 50CA issued a decision saying you can obtain this information through other means. They literally did nothing.
Counsel,
until-
if,
Yes, sir.
if Allstate had asked for an in-camera inspection, would the trial court have been required to do that, to perform that inspection, to satisfy their curiosity about what was in those records?
I believe that a new decision from this court, Dominguez and Value would affirm that position, yes. But I also think that the record bears out that I would not have opposed that. In fact, they're suggesting that I told the court it had to do an in-camera. No, I suggested that the court could remedy this with an in-camera if it deemed it necessary. But they never advocate. You know why they didn't advocate? Because Allstate's counsel multiple times said he knew that my client had cancer. That's borne out by the record. Also, dozens and dozens of medical records were put into evidence at trial that referenced by way of history the cancer. So this notion that I wrongly interjected cancer, respectfully, he read my client's testimony from trial, but what he didn't read was that they had asserted any objection to that testimony at trial. They did not. He also correctly read my closing argument, but what he didn't read is that they had asserted any objection to that closing argument at trial. They are the ones that created this defense, stating that my client only treated for 3 months following a crash and then disappears for 2.5 years when there was a very legitimate medical reason, which was both cancer and COVID. By the way, we haven't really talked about COVID, but because of my client's comorbidities at that time, it was a big deal. COVID, I don't want to get too dramatic here, but people who had the comorbidities were the ones that were passing. Ironically, Mr. Diaz ended up getting COVID, notwithstanding his efforts to remain isolated, and was hospitalized for the COVID. So those were very credible explanations for the gap of treatment that Allstate was attacking their own insured to say your injuries aren't as bad as you would have portrayed them to be, because you would have surely gone back to a doctor for neck and back pain if you had been in pain during that 2.5-year period of time. So with respect to all of the other remaining issues, I am making the concession as to the judgment. I feel like I'm duty bound to do that, but I don't believe that any other rulings were made in error. There has not been a
Let me ask you about the
preservation.
bias issue, because
Thank you.
it seems like there's two rules in the Florida rules of evidence on this that say you get to ask questions about bias. You got 9068-2, you got 96082, you got 9612 subsection 2. Both say you can attack witnesses for bias, you can cross-examine them for bias. So in order for us to conclude that it wasn't error to prevent them from asking about your relationship with Dr. Mahan, would we just have to assume that being somebody at groomsman 10 years ago is just too remote for a jury to possibly conclude bias? Like, how do we not find that error?
Thank you. That's an excellent point, because I do believe that remoteness at some point in time becomes a factor. But they also cite the Graham versus McKinney case, which is my case, where that judge, DCA judge, put in the decision that when you retain an expert, that you open the door to that type of inquiry. That Graham versus McKinney.
I saw that distinction in the briefs about the expert and the fact witnesses, and it just makes no sense to me at all, because either 96608 or 9612 make any distinction between expert and fact witnesses. It says a party, including the party calling the witness, may attack the credibility of a witness by showing that the witness is biased. Doesn't say only experts, doesn't say only fact witnesses.
So as to that issue, I think the distinction then is what truly defines a trial judge's discretion? Because the argument that they were advancing relating to him being retained expert, which, by the way, this proffer came after the testimony has already been presented to the jury, after Allstate's counsel has told the jury that he too, his law firm has retained Dr. Mahan as an expert witness. How Mr. Bird, me, has had Dr. Mahan testify as a treating doctor in other plaintiffs' trials. So the issue was before the jury with respect to bias.
That's contrary to our precedent. So we have a case called Middlebrook, where we just say like evidence of bias based on one reason is not a justification to exclude a different evidence of bias, right? Like each piece of evidence of bias stands alone, because the jury might think one shows bias and one doesn't. So just being able to say, hey, we're friends, or we had a relationship, or we've hired him for other cases, That's not a substitute under this court's precedent for being able to give one specific piece of evidence of bias, which in this case would have been, you were he was your groomsman. And so to just say, well, other evidence of bias was before the jury, it doesn't say you get to show some bias, but not others. I mean, the rules say you get to show whatever bias is there, and that's what our court said.
Well, I do think, though, that remoteness is a factor. I do think that the record will bear out that judge.
It's a factor, but that's what I'm saying. The rules say you get to attack the witness for being biased. They say that. Two different rules, clear as day. So is the only way we can rule for you on that issue is just to say this was so remote that no jury could possibly think this was bias? Like, is that the conclusion we have to reach to?
Well, and I think that
rule in
there's
favor?
a multitude of other factors. Number one, there was a motion in limine on that issue that was filed, that was granted. Number two, that motion in limine referenced other legal authority from the Florida Supreme Court relating to the constitutional right that experts have as to their own privacy and their personal life. We have the rule 1.280 that confines and restricts the scope of expert witness discovery. I do hear you, and I do understand that bias is in a different category, but when the Florida Supreme Court has curtailed that which lawyers can do with respect to experts, and specifically has identified that some discovery or cross-examination can result in a chilling effect, in that people who need legitimate doctors can no longer retain those doctors or have those doctors treat them, because the chilling effect that has been created by this personally invasive examination. Dr. Mahan actually testified specifically at the time of the proffer that this whole continued discussion and debate with respect to his personal matters has had a chilling effect. In fact, I think he even used the express words chilling effect, that he said, I'm no longer friends with Mr. Bird and don't socialize with him because lawyers like you keep bringing up my personal life. So I think
Counsel, I
Yes,
want to ask you on that point. You cite the discovery rule and case law that I think deals with the invasiveness of expert discovery. But if everybody knows that Dr. Mann was a groomsman in your wedding, it doesn't require discovery to get there. Why is that, necessarily off limits and cross-examination? I think you make the point in your brief that if it's not discoverable, then it's also not subject to cross-examination. But I don't find any support for that. I mean, if everyone knows he was your groomsman, they didn't have to get that information through discovery. Why can't they bring that up? Because the admissibility of bias evidence is completely separate from the discoverability of X, Y, and Z for experts.
So you were anticipating my response, which is if it's not discoverable, it's not admissible. But at some point, trial judges are there to monitor the situation at hand as things are unflowing or flowing at trial. And Judge Schreiber said, I've had this exact issue come up in other trials. I'm very familiar with this topic, and I'm going to sustain Judge Weiss's prior ruling to keep out the one question. We're talking one question. One question vitiated their right to a fair trial.
Question though, counsel, isn't it?
It's a
I mean, think about it. If you've got a dispute with somebody, right? Let's say, you've got a dispute with Bob over there. You need somebody to referee that dispute. And there's 10 referees you could pick. One of them was his groomsman 10 years ago. You're not saying, I want one of the other 9 just to be safe. You're not thinking, I'm worried that referee's going to like him better than me or have some allegiance to him. You're saying a jury couldn't look at that and say, it was 10 years ago, but I mean, that's a pretty close relationship, even 10 years ago.
I understand that when you retain experts, that was the factor with respect to Graham versus McKinney. I also hear you with respect to a general bias, but I also think you have to look at the totality of the record. You have to look at the fact that we have objective MRIs, objectively showing herniations, meaning it's not dependent upon anybody's word, whether it's a groomsman or not. You don't even have any opposition by the defense that the crash caused these herniated discs to enlarge. In fact, their radiologist offered—
Counsel, that sounds like a harmless error argument, but you didn't make one in your brief.
I don't know that they made a harmful error in their brief.
But isn't it your burden as
That's not the way
appellee?
briefing works.
Sorry.
Isn't it your burden as appellee under West Boca?
I understand that body of case law, but to be clear, I don't know that it was error. So then the harmless error. Bottom line is I don't believe that the judge abused her discretion, especially in the manner in which it was all presented in the.
Well, I get that, but assuming we do find it's error, we still need to analyze whether it's harmless error, right? That's another step in the process. And it's your burden. It wasn't raised in the answer brief. What do we do at that point? Did you waive it? Do we sua sponte have to look at that?
I do believe I briefed and quoted the Tran decision that talks about how it has to vitiate the right to a fair trial. One question in the scope of a lengthy trial with clear-cut objective evidence. I don't think Judge Shriver abused her discretion such that it would constitute error. In my mind, when I equate error, I'm thinking de novo review as opposed to abuse of discretion. But number two, this was well after the testimony had been presented to the jury. They asked for a proffer, they're given the proffer. The judge analyzed the issue and said, I'm familiar with the issue. I'm going to.
You said it was after. I mean, it wasn't too late for them to ask Dr. Mahan about it though, right?
It was not too late in the sense that they were timely in asking for the proffer and the proffer was made. But by that point, the jury is now left for lunch and the judge didn't find it germane, given that there was already a discussion about friendships, that there was already a discussion about how defense counsel and Allstate had retained Dr. Mahan as their expert in their cases. So I do think that this issue of bias was fully flushed out. The one question that is remote in time, that is more than 10 years ago, now more than 11 years ago, but at this time it was 10 years ago, that doesn't vitiate their right to a fair trial under the Tran decision. That's my position with respect to that.
Counsel, I want to go back to the discovery point. If we were to analyze this, this issue of his participation as your groomsman from a discovery standpoint, under 1.280, under the portions that you cite in your brief about what is permissible expert discovery, one of the lines of questioning is the identity of other cases within a reasonable time period in which the expert has testified by deposition or at trial. If in the course of asking that question, tell me all the other cases that you've testified in, and there are 100 Jeff Bird cases and 2 for other lawyers, wouldn't it be an appropriate follow-up to say why so many cases for Jeff Bird? And depending on the answer to that, does it have anything to do with the fact that he was a groomsman at your wedding or something like that? In other words, the discovery is allowed into what other cases an expert has testified in. If there are some large number or disproportionate number for a particular lawyer, wouldn't it be within those discovery limits to follow up and ask why that was, explore all the reasons why that may be the case?
There was no discovery conducted on that point, so I'd be engaging in speculation as to what the response would be. So all I can say in a speculative nature is Dr. Mahan is one of the few radiologists in Central Florida. There are other radiologists who will read images in Central Florida, but they're outside the Central Florida area, most of them. Indeed, their expert, Dr. Negan, is from down in West Palm Beach, Fort Myers. So is it any shock that someone who has an office here locally, who is retained by all of the local centers as an independent contractor, would read so many studies that I may thereby represent folks who've had MRIs read by him? That would have been the plausible explanation.
I don't disagree with that. That's a plausible and perhaps the correct answer to the question. But I'm getting at, you make the argument that if it's not discoverable, it's not admissible. And I'm just wanted to press on the idea that it's not discoverable to find out what cases a doctor has testified in. And then if it looks like there's a large number for a particular lawyer or on the particular side, plaintiff versus defendant, why further inquiry couldn't be made as to why that might be the case, which seems like it would open all the doors of potential bias that we're talking about here.
I don't think that would be prohibited discovery, but it wasn't attempted in this case. I don't think that opens the door, or otherwise we might as well throw out the Elkins decision, the Worley decision that talk about the chilling effect on treating doctors and patients having access to high quality treating doctors. If those treating doctors, the chilling effect is such that they no longer wish to participate in the legal process because they're tired of their personal life being made a spectacle of. People are allowed to have friends. Lawyers are allowed, I'm allowed to have friendships with judges and socialize and go to dinner and lunch with judges. I understand that somebody's going to say, well, what a groomsman is a different category. Okay, he was one of 10.
You know, so that's the point. If you had a witness, everyone's allowed to have friends, obviously. But if you had a witness on the stand who was your friend, the other side usually ask, hey, aren't you friends with Jeff Bird? Right? Like the friendship would normally be, why would that not be within the realm of bias? I mean, people are allowed to have friends, but they're not immune from questioning about it under the rules in terms of bias.
To be clear, that was not prohibited. That was not precluded by Judge Schreiber.
Yes, but the extent of it was, right? And, you know, there are different things that can evidence bias, and they were allowed to ask about some and not others, and you're running square, and we've got a precedent on this. It's called Middlebrook. And it says that you can't evidence of one type of bias or one reason for bias is not a substitute for a different evidence of bias.
I see I only have 20 seconds. So to your point, again, there was evidence of bias. There was abundant evidence of bias. They weren't precluded from asking about a friendship. To me, and I realize I'm not sitting in your position as a judge, but it wouldn't be relevant if somebody were running a race together, a 5K race together, golfing together, play poker guys nights together. You are entitled to maintain a privacy with respect to your private life and private affairs, but it's not prohibited to ask, do you have a friendship outside the courtroom? And that wasn't prohibited in this case. I see I'm now over time. Does the panel have any further questions? Otherwise, I don't believe that Judges Weiss or Judge Schreiber, both very experienced judges, abuse their discretion in any respect in this case. I thank you for your courtesies today.
90.608 says any party may attack the credibility of a witness by showing the witness is biased. It doesn't have any limitations on whether or not you're a groomsman or you run 5Ks or anything like that. If it's biased, it's allowed to come in. As to the treating versus experts, State Farm versus German, 12 Southern 3rd, 1286 from the 5th ECA. Quote, a treating physician, just as any other witness, may be questioned at trial concerning any bias he or she might have for or against a party. Then goes on to say, quote, there is no logical distinction between treating physicians and retained experts for purposes of uncovering this type of information. The timing of the proffer really is irrelevant because there was a motion to eliminate granted before trial that precluded this evidence from coming in. There is no argument for this court that this was harmless error. And in fact, there is a tremendous amount of evidence that this was harmful error. Why? Because that Mr. Bird specifically told the jury, hey, look, the defendant has retained this Dr. Mahan in the past. We didn't get to talk about the close personal relationship. Mr. Bird argued in closing that the jury should believe Dr. Mahan because he was the top of his medical school and had been a defense expert in the case against Bird. Again, this was a significant closing argument to the jury. And there's an issue that I admit is not preserved, but this court may consider it nonetheless in terms of cumulative error. And that is a probably a unique situation where Dr. Mahan was testifying and he was asked, when was the last time you testified in trial? And he said it was yesterday. In fact, there were people in the back room, and he's referring to jurors from that case sitting in the back of the trial that he is testifying in now. Those were the jurors in the trial that I testified in yesterday because the case settled after I testified. He is alluding to the fact that the jurors in some other case are so interested in what he has to say that they're going to come to a different trial to listen to what he has to say and suggest that they favored him so much that they went out of their way to watch him again, and they agree with him. That is significant, and I concede it was not objected to, but in the totality of the circumstances which this court can consider in determining whether this had an impact on the verdict, that did. And I rely on the case Domino's Pizza versus Wiederhold, 248 Southern 3rd, 212 5th DCA 2018. In evaluating errors, we consider the cumulative effect of both preserved and unpreserved error. Very briefly, I do want to mention that at the hearing for the, trying to get the cancer records, Mr. Byrd said it requires an in-camera review by the court. This is on page 318 of the record. The defense counsel said, quote, "We should be able to look at these records." And the judge said, "I'll look at the issue and get you all a decision on that." And then the written order says, the medical records related to plaintiff's prostate cancer treatment shall be protected from discovery as they are unrelated to the accident at issue in this lawsuit and violate the plaintiff's right to privacy. So that leads me to believe that the judge wrote that because he looked at these records and said they are unrelated. So that issue is preserved. Your Honors, we would respectfully request that this court reverse and remand for a new trial. And of course, we rely on the other arguments that I did not have time to get to that are in the brief. Thank you very much.
Thank you. We'll be in recess before the next case.
Can you hear me now or no? Is it? Yeah, but not the audio.
About now, test 1, 2, 3. Test 1, 2, 3.
Not hearing that one.
Test.
Hang on. Hey, does it? It's not okay.
The door's not working.
Can you hear me? Let's move on to the other one. You hear me on this one, Pedro? About this one.
That's a bad one. Which one is this? That's good for all, okay.
He said he heard me on that one.
All right. please be seated.
Okay, our final case on the docket today is 24-1679 Constantine K. Yankopoulos versus Terry Yankopoulos, NKA Terry Turner. How much time would you like for rebuttal?
5 minutes, please.
Okay,
Good morning.
you may proceed.
Good morning. May it please the court. My name is Jason Margarella, and I represent the appellants, Constantine Yankopoulos, who I'll refer to as the husband. This is an appeal of a judgment dismissing a petition to modify alimony. The parties petitioned for dissolution of their marriage in 2007, and in 2008, they reached a settlement agreement. Under the terms of the settlement agreement, the appellee, who I'll refer to as the wife, received the lion's share of the party's assets, including the marital home, and the husband was required to pay $7,000 per month in alimony. At the time, the husband was a practicing physician. He had his own medical practice. He served as a medical director, and he.
We know the facts, counsel.
What's that?
We read the brief, we know the facts.
Okay. Since the time of the agreement, he lost his medical license. There's the change in circumstances was that, but also, and the one that I want to focus on here today is the increase of income that the wife started earning between, again, the time 2008 and 2024. So,
Counsel, can I ask you a
yes.
question about statute 61.14? As I read the statute, a substantial change in circumstances, assuming that criteria is met, it just opens the door for the trial court to then look at everything and then giving due consideration to that change, either increase, reduce, or keep the same, the alimony award. So my question is, even if it's true that the wife's need decreased by $5,000 or $6,000, does that necessarily mean the trial court must lower or decrease the alimony by the same amount? Or could the trial court say, well, based on the ability to pay now and the need now, 7,000 is still a good number, so I'm just going to leave it where it is?
I think the trial court had the discretion to do that, but that's not what the trial court actually did. The trial court found that there was no substantial change in circumstances, and that was based primarily, well, there was two things. In the oral pronouncement at trial, the court said that the wife still has a need for the alimony, irrespective of the adult disabled son's expenses. But in the judgment, she relied on the adult son's expenses in finding that there was no substantial change in circumstances. So that's the error in this case. Again, the wife, her income did go up significantly. Went from $0 to $5,319 per month, and that was based on her sale of the marital home for $2.2 million.
Is that an unexpected change in income?
There was no evidence that it was contemplated at the time.
So you get a final judgment that says the house will be sold, right? That's in the final judgment, says the house is going to be sold. And they said at the final hearing, they expected the house to be sold. So the sale of the house was clearly contemplated. The only way I could see that you're saying the income wasn't contemplated is that it was contemplated she would sell the house, but not contemplated she would get any income from the proceeds. Is that the argument?
Yes, there was no discussion about what income that would yield and how it would be invested or what it would do. And also, I think there was a little bit of a question mark as to whether or not she was actually going to sell the house. At the time of the hearing, she hadn't even listened.
Well, it doesn't say it has to be fully certain. It says it has to be contemplated, right?
Right, that's the one.
Yeah.
Contemplated.
Yeah.
Yes.
So of course, I know there's some give in the case law between foreseeable and contemplated. Contemplated with a stricter version,
Right.
That you would want. At least the sale of the house, when the final judgment literally says when the house is sold, I think you've got a really uphill battle saying nobody contemplated the sale of the house.
I think our position is more on the income. There was no contemplation at the time that they entered into that.
All right, so you concede they contemplated the sale of the house, just not the income she would receive from the proceeds.
Well, based on my view of the record and looking at the transcripts of, the discussion that was had at the time that the agreement was announced in open court, I think there was a big question mark still as to whether or not the house.
So counsel, when I ask a question, I need you to give me an answer. I didn't say whether
Yes.
they knew it was certain. Okay. I said whether they contemplated it. They talk about it being sold, or they use the term when, final judgment refers to it being sold. All right, do you think it's an open question as to whether, not whether it was to her certain, but whether it was to whether it was contemplated that she would sell the house?
I think it's fair to say that it was in contemplation that the property would eventually be sold, yes.
Okay, so you concede it was contemplated the property would be sold, correct?
Yes,
Okay, but you think the income she got from the proceeds was not contemplated?
absolutely, not contemplated. It wasn't discussed, and it was income that didn't start to accrue until, literally like.
Let me ask you this, if she had rented out the house instead of selling it, would the rental income have been not contemplated?
I don't think there was any evidence that there was a contemplation of income associated with the property at all.
I guess I'm saying when you get a big piece of property and everybody knows with certainty you're gonna have the property, and at least contemplates the property will be sold, if not certain it's sold, they contemplate it will be sold. It just, is that not inextricable from the fact that you're gonna do something with the proceeds, and you're gonna get a big pile of money? Like, how can you say you're gonna contemplate selling a house but not contemplate getting a bunch of money?
Well, I mean, there are different things that can be done with the money, obviously. I mean, there's not a requirement that she take the proceeds and then invest them. She could have purchased a new home. She did purchase a new home, but she purchased a much smaller home.
Let me ask you, if she had gotten that money and just blew it, she went to Vegas, had the best week of her life, spent all the money and never earned any income. So in that case, would she have no change in circumstances because she didn't have the income?
I believe, yes. I think there would be a much different, discussion.
So if she had blown the money, she would have kept her alimony. But because she did something productive with it, she loses the alimony.
Well, yeah, and it's for a reason, because she is actually earning an income. Like, for example, she took $240,000 from the proceeds of the sale of the house. She invested it in her son-in-law's pool company that went nowhere, and she just lost the money.
Yeah.
We're not saying that
But
money
you
should.
can see it under the way you're asking us to argue it, to decide it. She blows the money, puts it on racehorses, keeps her alimony, does something productive, loses the alimony, right?
I think that's because in one case she's.
Because I'm not asking for because.
Yeah.
When I ask you a question, I need the thing that you respond with to be the answer to my question. Is that understood?
Yes, I agree
Okay.
with,
So-
what you're saying.
Do you agree with how I'm characterizing it?
Yes.
Okay.
I think that the difference is, if I could explain why.
I'm okay with explanations. I just need the answer first.
Sure,
Go ahead.
sure. Okay, so yeah, I mean, there's a couple things about contemplation that I do want to focus on. Number one, this wasn't a developed factual issue below. The trial court did not deny or dismiss the petition to modify based on the fact that the sale of the home was contemplated. So that was something that was brought up in the answer brief. And I know there is the tipsy coachman doctrine, in which case the court can be affirmed based on matters that were not raised. But we're talking here, I think, about a factual issue, specifically contemplation, that there could have been additional evidence that would have been introduced on that issue to address it, to determine whether it was in fact within contemplation.
Counsel, on that issue, can't we look at the judgment and the transcript of the agreement that, as it was announced in open court, and just say as a matter of law, they were at least thinking about selling the house? In other words, can't we, I understand, I think the distinction you're making between a tipsy coachman affirmance on, on some legal issue or something that's in the record versus tipsy coachman affirmance based on a finding that was never made by the trial court. But here, can't we simply look at the face of the record and see contemplation of sale of the house? It's right there. Now, understanding that leaves a question about what was contemplated as to the proceeds, and maybe that's where we need to focus. But there was at least contemplation of selling the house on the face of the record here, correct?
Yes, I think, I mean, to me, it's a little bit, it's not exactly a black and white issue. I think there's an area between, we're going to sell the house and we might sell the house. And this kind of is somewhere in that gray area, but I agree that the fair characterization is that they did contemplate that the house would be sold.
Does it make a difference in this case that the original alimony amount was based purely on agreement? In other words, there were no findings made in the original judgment as to ability to pay on the husband's side and need on the wife's side. They just said, we agree to this number. In the context of, and she's going to get a $3 million unencumbered house. Shouldn't that make a difference in terms of how we view what was contemplated based on the fact that it was all agreed to? This was a number they came up with, presumably after some deliberation and consideration, versus the trial court saying, here's the ability to pay, here's the need. Based on that, I get to this number, which seems like it would leave for the future determination if something about those numbers changed.
Right. Well, I think the agreement was, as what was underlying the agreement as to alimony was an agreement as to need. The husband had the reported monthly expenses from the wife in her financial affidavit at that time. You know, they came to this agreement basically saying that with those monthly expenses, $7,000 a month is the need for alimony. And, you know, as those circumstances changed, you know, I think the way that the trial judge was kind of looking at this and sort of lost sight a little bit of the purpose of alimony, right? It's to maintain the standard of marriage that was established during, or the standard of living that was established during the marriage. And you're right, there was no evidence as to lifestyle or things that might support a finding as to the specific amount that was needed to maintain the lifestyle that was established during the marriage. Well, all we have is the agreement that $7,000 will do the trick. And as the circumstances then changed after that fact, well, now $7,000 is more than enough to do the trick. It goes beyond what would do the trick. And the reason why is because if you look at the monthly expenses between, again, 2008 and 2024, those didn't really change much. I mean, they did go up a little bit. And in our brief, we do, you know, say, well, if we pull out the expenses to the extent that they went up and that they were supported, there's still an additional $4,000 a month that she's now earning that she wasn't earning at the time that could be used to satisfy that agreed upon need of $7,000 per month.
Does the trial court have to assume that that the agreed amount of alimony at the time of the original final judgment accomplished that you know, that goal of keeping the wife at the level of income or the standard of living that she had enjoyed during the marriage? Or the fact, based on the fact that that was just an agreement, and now we have the trial court sort of opening everything up again, does the trial court have the discretion to say, yeah, her income's gone up $6,000, but I think that the number she needs to maintain that standard that she enjoyed when she was married is 13,000. So I'm going to keep the 7 in place because, you know, now is the first chance I've had to actually do a full accounting of what that standard should be. And I still think that number is correct.
Yeah, and I think, well, I mean, there's two things. Number one, are we going to honor, is the trial court honoring the agreement or not? And I don't think under those circumstances, she would be honoring the agreement because she's deciding, well, I'm going to basically take a fresh look at this and see, what is the need for alimony? So I don't think the trial court, I think it would have been erroneous, it was erroneous for the trial court to just simply you know, not uphold that agreement. But to the extent that there could have been a finding about the amount required to maintain the lifestyle during the marriage at that point in the proceeding, what there should have been was evidence on that. And that would have been the wife's burden to introduce that evidence as the party, not only the party seeking alimony, but also in the context of the petition to modify after the substantial change has been established with her increase in income, then the burden then switches over to the wife to establish that, hey, I still need this alimony. And so what does that require? That requires evidence of what was the lifestyle that the parties enjoyed during the marriage. And typically we see, you know, experts opining on that, reviewing expenses and, you know, lifestyle choices that were made during the marriage. And none of that was done here. The trial court looked solely at the wife's expenses as of the date of the trial and didn't give any, there was no evidence for the court to consider as to the lifestyle that was established during the marriage. And so without that, even if the court could just disregard the agreement on the $7,000 being the need for alimony based on the expenses that were reported back in 2008, there was still insufficient evidence to support the judgment dismissing the petition to modify. And I'm a little bit close here, so I would, unless there are any further questions right now, reserve the rest of my time for rebuttal.
Good morning, Your Honor. May it please the court, my name is Allison Perry, and I, along with Linda Fried, represent the appellee, the former wife, Terry Turner. This case, of course, there has to be a substantial change in circumstances. It was not contemplated at the time of the final judgment in order to get a modification of an alimony award. Here, the court found there was not a substantial change in circumstances, and the court did have evidence as to what the standard of living was at the time of the agreement, because the former husband's financial affidavit was November 19th, 2008, and the agreement was reached the next day. So,
Wouldn't it have been the former wife's affidavit or standard of living that was relevant, though?
yes, and the former wife's financial affidavit, I believe it was like May of 2008.
So when that was on the record from the prior
Yeah.
proceeding, right?
Yeah.
Does that make it evidence in the supplemental petition trial?
Well, the court, I believe the court took judicial notice of the entire file.
When you take judicial notice of a file, does that constitute judicial notice of the truth of the facts within documents of the file?
Well, these are notarized financial affidavit.
In other words, hearsay?
Yes,
Hearsay is not admissible?
hearsay is not admissible.
And so I guess back to the question I asked you then, if you take judicial notice of a court file, right? Does that constitute judicial notice of the truth of all facts stated within documents in the file?
No, but it was not contested that these were the expenses of the parties at the time they entered into the agreement.
Well, if something is never entered into evidence, do you need to contest it? You don't contest things that haven't been entered into evidence, do you?
Well, it was discussed and no one objected during the trial. So the sale of the house was clearly contemplated at the time of the final judgment. So the proceeds at the time of the final of the agreement, the wife's living expenses totaled over $14,000, and that was not including the adult disabled child expenses. So she agreed to get $7,000, which was much less, which is half as much as what she needed to maintain the marital standard of living. The husband's financial affidavit at the time in 2008 said his expenses were $19,000 and that he was earning negative income. So there is no substantial change in circumstances as to the former husband's income. He's actually making a lot more than he was making at the time. As far as the wife's income, it was contemplated that she would sell the house, and clearly she was planning on living off those proceeds because her standard of living was much higher than the $7,000 allotted in the for permanent alimony.
Counsel, I want to ask about the fact that this was the marital home. I'm wondering how we might look at that differently in terms of what was contemplated. If in a settlement agreement like we have here, the wife gets the marital home, and granted, it's a large asset. It's worth $3 million by their estimate back then. Is there not some expectation, even though maybe she'll sell it one day, that as long as she's living in that house, she's not making any money off of it. There's some expectation that she can stay there. But as soon as she sells that house, all bets are off. I mean, you have a lot of money that she didn't have access to before, and now she does. Even if it's the sale of the house was contemplated, is any income she makes off of that sale just off limits as being previously contemplated, or how do we decide, how much income from the sale of a big asset like that is contemplated and how much isn't?
Well, here it was contemplated that they'd sell the house. She stayed in the house, living off of her share of equitable distribution to support the house, because the expenses of that marital home were almost $7,000 just for the marital home expenses. So the income derived from what excess she invested, because she bought a house with proceeds and then she took $800,000 and she put it in a CD. Now, I think it was contemplated that she was gonna get a substantial amount of money for the house, when she actually got $800,000 less than was contemplated.
How
She
much
only,
does she have to get before it's not contemplated? Like, obviously, if you're gonna sell the house, you assume there's gonna be some money involved, right?
oh, okay, let's
But-
say she's,
Like, for instance, what day was the house sold? What was the date of the sale?
it was 2017.
So let's say there's a market price for that house and she just drastically exceeds it, right? Let's say they find a gold deposit underneath, whatever, a celebrity moves in next door and everyone wants to buy the house. Like you could see a situation in which, yeah, they contemplated the house being sold, they contemplated some proceeds, but this is an unexpected amount of proceeds, right?
Absolutely. And in the final judgment, it said they expected the house was worth $3 million. It ended up only being worth 2.2. If it would have been the opposite and it was worth $5 million, then that extra $2 million absolutely would be a substantial change in circumstances that the court could take into consideration. Because no one thought she was going to make an extra $2 million off that sale of the house, and that would just increase her needs that were contemplated at the time of the final judgment or the agreement. I think that there's an abuse of discretion standard, and that means that no reasonable person would have made this decision. And I don't see how that it can be reversed on the grounds that no reasonable person would say, hey, there hasn't been a substantial change in circumstances and there's still need established. So I ask that you affirm and also award her appellate attorney. Are there any
It's a
more
conditional award you're seeking, right?
questions? Yes, conditional award. Thank you.
Thank you.
Thank you. I just want to briefly address a couple of the statements that were made by the appellee's counsel. She talked about the standard of living based on the affidavit. And I think there's this misconception that just because it is a monthly expense, it is establishing a need for alimony. Monthly expenses are not the same as the amounts needed to maintain the lifestyle that was established during the marriage. And what we're looking at, and what we should be looking at in context of an alimony determination, is what is the amount that's needed to establish the lifestyle or to maintain the lifestyle that was established during the marriage. And the only thing that we have is these affidavits saying, basically, here it is. We had $16,000 of expenses before. We have expenses now that are a little bit more. And so our standard, the standard of living that was established during the marriage is essentially, the same as it was.
To address your opposing counsel's point that the house sold for less than was contemplated at the time of the final judgment.
Well, yeah, I think there was on the record when they announced the agreement in open court, even my client at that point indicated that it's worth $3 million, but there's no buyer for it right now. So then that's one of the reasons why I think it's not as clear of a contemplation of a sale maybe than
But they got less than the 3 million, right?
they did.
Yeah, they didn't exceed what the house was contemplated to sell for, right?
I think the husbands believed that the property was worth $3 million at the time of the judgment, and it sold for less than that.
Yeah, so it did not exceed what was the contemplated price.
Not with the husband's contemplation. I don't know that there's anywhere else in the record where.
So the sale of the house was contemplated, you conceded. The amount of the proceeds was contemplated, you conceded. So the only part here that could have been uncontemplated was that she would get some income from those proceeds, right?
Well, that certainly was not contemplated.
Well, I'm saying, but that's kind of that's the thing we have to find, because we don't get to the issue of need and ability to pay if there wasn't a substantial and unexpected change in circumstances. And the only unexpected change you could get here, right, is not the house being sold, not the amount of the proceeds, but income from those proceeds. That's the only part that could be non-contemplated.
Well, I think there's also the Social Security payments that she started receiving.
But in terms of the house.
In terms of the house, yes. But one thing that the appellee's counsel did also mention was that the expenses that she had associated with the house went down after she sold the house. And this is consistent with, if you compare the two affidavits, which again, they're not admissible, but we're looking at, the record with every.
So the current affidavits you know, that existed as of the time of supplemental petition, those were admitted, weren't they? They were admitted in the supplemental petition trial, weren't they? Because here's the thing we have in family law cases. Affidavits are hearsay. They can't be admitted over objection. But in every single family law case, people admit the affidavits and nobody objects. So you have this document that is obviously inadmissible hearsay admitted as evidence in almost every single family law case. And that's what happened here. So I take your point about, you know, the affidavits from the original trial, but the affidavits for the supplemental petition proceeding, those were admitted. You didn't object, right? And whether it's hearsay or not, it was admitted without objection. So that is evidence, right?
If it was admitted, but I guess, you know, if it was, I mean, I'm assuming for the purposes of this appeal that both of the affidavits are accurate, to the extent, you know, that they say what they say. I mean, I'm not disputing that, but if you just put in an affidavit, you know, my monthly expenses are, you know, XYZ, that doesn't establish that, hey, those are.
But it does though, because that's testimony. Like when it's admitted, now normally you can't admit that. It's hearsay, right? So if somebody objects and it doesn't come in, then I agree an affidavit doesn't establish anything because it's not admitted evidence.
Right.
When you don't object and let it get admitted, now it does establish things.
Well, yeah, but I mean, I think what I'm referring to is that there was some discussion about the affidavit, right? It was, okay, walk us through it at trial. What are, you know, you have this big increase in the adult son's expenses, right? It went from, you know, being, I think something like 1,500 or something at the time in 2008 to being over 3,000 at the time.
What you have is you're saying you have some conflicting testimony.
Well, there was other than that sort of self-serving statement in an affidavit, there was no evidence.
But is there any rule that says self-serving testimony is not admissible?
Well, no, but we're looking at, should be substantial competent evidence.
Okay. So is there any rule that says self-serving testimony is not substantial competent?
No. Well,
So that's
no.
Yeah. Okay. So you have testimony in the affidavit, which is admitted, you didn't object, you let it in. You have other testimony that you think muddles it. So it sounds like you have two different pieces of testimony trial judges look at, right?
Well, I think but I think that when you know, your question, you have a witness on the stand, they reported something in an affidavit in a conclusory fashion, and you start asking questions about that, and they can't substantiate the statement that's made in the affidavit. Now, I think there's potentially, now, depending on the circumstances, in this case, I'd say there was no substantial competent evidence supporting, you know, at least a portion of the expenses that she reported in her 2024 affidavit. And that's our second point on appeal, is that there was $975 that were of monthly expenses that were just not supported by anything other than, you know, her saying that she had those expenses.
Counsel, I want to ask you if it's possible to kind of separate out the different points you've made. For example, if we were to conclude that not only the sale of the house, but the income from those proceeds was contemplated and therefore off the table on a substantial change in circumstances analysis, could we still rule in your favor based on what's left? And on the other end of that, let's say we recognize the income as a substantial change in circumstances. Does the $975 really matter as a substantial change in circumstances?
Well, I mean, I think when you're looking at $7,000 a month, $975 is substantial, but it's more about, you know, combining the different factors when you're looking at, you know, substantial change in circumstances. That's the way that I look at it. But I think $975 or $975 independently, based on a $7,000 a month alimony obligation, is substantial. Certainly, the court could deny or find that the income from the house was contemplated and still find that the Social Security benefits were not. And that is another piece, which is, I believe, it's in the brief, but it's $2,227 per month. And then I think the last issue that on appeal is this imputation of income of $850 based on the money that she could have made off of the $200,000 that was not invested after the property was sold. And those three issues, I mean, either one of them would reduce the need for alimony, again, based on the agreement. They're not, you can whether you rule against us on one, you can rule for us in favor of us on the other, 100%. And that's for those reasons, we would request that the trial court be reversed and that the case be remanded with instructions to basically reduce the amount of alimony in accordance with the court's conditions.
Thank you,
Thank you.
counsel. This court will be in recess.